This talk's been billed as a legal perspective, but perhaps it'd be better to call it legal problems and obstacles rather than a perspective, though I do hope to come forward with some possible solutions as well. But I think it is important that we do keep our feet on the ground when we're involved in the campaign, that we do recognise these particular problems. So the first thing I'd like to talk about is, who do the sculptures belong to? Or perhaps you should say, who do the sculptures belong to, brackets, in English law, close brackets, because it would be English law that would be applied if there were to be a legal challenge. The issue of ownership of the sculptures has obviously vexed politicians, curators, campaigners and the public for decades. The way the sculptures came into the possession of the British Museum is a matter of relatively settled historical record. Lord Elgin removed them from the Parthenon under an Ottoman firman, the legal effect of which has been hotly disputed ever since. The first argument is that the firman did not extend to the wholesale removal effected by Lord Elgin, and secondly that the firman could not and did not lawfully allow the removal of the sculptures anyway. But be that as it may, Lord Elgin shipped the sculptures to his London home, his expenses were substantial, and his subsequent financial difficulties led him to negotiate for the sale of his collections to the British Museum. In 1816, a House of Commons Select Committee considered the authority by which Lord Elgin's collection was acquired, the circumstances under which that authority was granted, the merit of the sculptures and the importance of making them public property, and their value as objects of sale. The committee had judged the sculptures to have been properly acquired, that they were both fit for and worthy of public purchase, and recommended a purchase price of £35,000, less than half the expenditure claimed by Lord Elgin. And when the report was debated in the House of Commons, the House voted the money for the purchase by 82 votes to 30, and legislation was then passed giving effect to the recommendations. The collection was purchased from public funds, and the ownership was vested in the trustees of the British Museum. So the British Museum and the UK government's case is that the trustees of the British Museum are the legal owners of the Elgin Marbles, as they call them. They were vested in the British Museum by an Act of Parliament in 1816, and that's an end of the matter. Of course, there have been suggestions that the BM's ownership could be challenged, but the only way of resolving an ownership issue definitively would be a court declaration or judgment. But anyone trying to achieve that, I think, would face insurmountable obstacles. The first question, of course, is who owned them in 1816, before Elgin removed them? Was it the Ottomans? Was it the Greek people, as some say? But of course, there's no Greek people as such recognised in law at that time. And of course, when the Parthenon itself was built, there was no Greece. Greece was a combination of city-states, all independent of each other. After they were made, after the Parthenon was built in Athens, Athens was conquered by the Spartans, conquered by the Macedonians, by the Romans, and ultimately the Ottomans. So who actually owned the sculptures in 1816? Bearing in mind that the modern Greek state wasn't even in existence at that time. Could ownership vest in the modern Greek state created in the 1820s as a consequence? All very, very difficult questions. It would be necessary to establish and then apply the law of property and of contract as it stood in 1816. Anyone challenging ownership would need to prove the museum had not lawfully acquired them then. And a major obstacle is the 200-year delay and the law of limitation. Now, one could argue that the trigger point for limitation law, the law of property, would be 200 years ago. I think that's probably wrong, but I certainly think anyone opposing this could create a strong argument that the limitation period would at least start from when the campaign began in the 1980s, and that would certainly create a significant difficulty. It would be necessary to prove that the 1816 British government was not a bona fide purchaser for value without notice. And although we'd have to go back to the law of 1816, the law of property hasn't changed a great deal as far as the basic principles are concerned. An innocent party who purchases property without notice of another party's claim to the title of that property is entitled to keep that property, even when the property may have been fraudulently sold, because the bona fide purchaser usually takes good title to the property, despite those competing claims of the other party. And I may be corrected on this, but I'm pretty sure that in 1816, before the Select Committee, the Ottoman government did not try and challenge at that time, before the committee, the right of Lord Elgin's ownership. So I think there's really significant difficulties, particularly bearing in mind the parliamentary extensive debate at the time, which actually examined this precise issue as to who owned them. And as the purchase and transfer was by Act of Parliament, any challenge would also face the overwhelming hurdle of the supremacy of Parliament too. Parliament has in the past overridden private property rights of the public good, including without compensation on occasion. For example, after the Second World War, when we were looking at some of the compensation claims for war damage, Parliament passed laws saying, okay, you can't have compensation. The best example was the Burma oil claim against the government for the destruction of the Burma oil fields by the Japanese. An act of Parliament was passed retrospectively to say you couldn't have any money. They couldn't have the money. So any legal challenge could be expected to end up in the Supreme Court. And given my analysis, I think that would pretty well be a lost cause, bearing in mind the court would be applying English law. I think it would be very difficult to find a no-win, no-fee lawyer prepared to take the case on all that way. But in the end, does ownership actually matter in the campaign? A legal challenge would be an expensive and time-consuming sideshow, in my view, because the political debate has moved on from the question of ownership. Moreover, if there were to be a legal case, and it did fail, as I think would probably be likely, such a defeat in the courts would be a major setback for the mainstream campaign which has been outlined by the platform so far. And even if the case was successful in arguing the ownership, it would probably still need a change in statute law to allow the British Museum to actually implement a court judgment. So I think the real issues now generally seen by campaigners both in Greece and in Britain as not to be who owns the sculptures, but where they're physically located, with suggestions about loans of the Parthenon sculptures or BM annex in Athens as part of the new museum, for example, being part of that debate. The moral and political arguments about the point are for other presentations at this colloquy, and not for my paper, but resolving the issue of location itself raises legal issues which are at the very heart of the debate. The major obstacle which has to be overcome is the British Museum Act 1963, under which the Parthenon sculpture collection is held. So I'd now like to just outline the legislation. It's not just the 1963 Act, there's been other legislation as well. And in my paper I reproduce in full, in its current form, the 1963 Act as an appendix. So anybody who wants my paper can actually see what the law actually is now. The purpose of the Act when it was passed was mainly to provide for the separation of the Natural History Museum collection from the British Museum to set up the Natural History Museum itself as a separate entity. But of course, in summary, it has other effects too. The relevant provisions are that the British Museum trustees have power to enter into contracts and other agreements to acquire and hold land and property, and to do all the other things that appear to them necessary or expedient for the purposes of their functions. The trustees must keep the collections of the museum within its authorised repositories, except if it's expedient to remove objects temporarily for any purpose connected with the administration of the museum and the care of its collections. The trustees, so far as it appears to them to be practicable, must ensure the objects in the museum, including reserve collection objects, are made available for inspection by members of the public. The trustees may lend for public exhibition, whether in the United Kingdom or indeed elsewhere, any object comprised of the collection of the museum, provided that the trustees have regard to the interest of students and other persons visiting the museum, the physical condition and degree of rarity of the object in question, and regard to any risks to which it's likely to be exposed. Objects vested in the trustees as part of the collections shall not be disposed of by them otherwise than under Section 5 or 9 of the Act, and also, subsequently, Section 6 of the Museum and Galleries Act 1992. Section 5 of the Act provides that the trustees may sell, exchange, give away or otherwise dispose of any object vested in them and comprised in their collection only if the object is a duplicate or the object appears to the trustees to be made not earlier than 1850 and is mainly printed matter. Obviously that doesn't apply to the sculptures. Is in the opinion of the trustees the object is unfit to be retained. Obviously that's not their view. And is in the collection of the museum and can be disposed of without detriment to the interests of students. Section 9 of the Act is no longer relevant because this only relates to transfers between the British Museum and the Natural History Museum. There have been three other relevant bits of legislation. The first was the Museum and Galleries Act 1992, Again, I reproduced the relevant bits of this legislation as appendices to this paper. Section 6 of the Museum and Galleries Act 1992 allows the transfer of objects or related documents between institutions if the transfer is to any other body for the time being specified in the Act. And that's a list of specified bodies, which are in fact major museums and galleries, all of which are situated in the UK. Subsequent to that, the Human Tissue Act 2004 enables the trustees of the museum to deaccession human remains if it appears to them to be appropriate to do so, and there have been some claims from indigenous peoples around the world for various items to be returned, and I'll mention one of those later on, which actually was returned by the British Museum. Most recently is a private member's bill which I took through Parliament and which became law and is now in effect. The Holocaust Return of Cultural Objects Act 2009 confers power to return certain cultural objects on grounds relating to events occurring during the Nazi era. It applies to a list of bodies which includes the British Museum. A body to which the Act applies may transfer an object from its collections if the advisory panel, and I'll mention that in a minute, has recommended the transfer and the Secretary of State has approved the recommendation. The advisory panel is a committee of the great and good which considers claims made by putative owners of looted art, in effect, and which was stolen during the Nazi period or disposed of under forced sale. And there are some interesting examples about this. For example, there's a pair of vases, one of which was held in the Fitzwilliam Museum, and I think the other was in the Victoria and Albert. One was allowed to be returned under existing law, the other one could only be returned under this Act. The most famous case actually is the Benevento Missal, which is an object held in the British Library, and wasn't owned by a Jewish family actually, it was actually owned by an Italian monastery, and that had been looted during the Second World War and ended up in the British Museum, the British Library rather. The British Library wanted to return it, the owners wanted to claim it, but the law did not allow it to be returned. But now it can be returned under the 2009 Act, though there are arguments about the detail and the conditions in which it's going to be kept and so on. So, what's the effect of the current legislation in summary? Well, basically it forbids the museum to dispose of items except in only limited circumstances, such as duplication, post-1850 printed material, or something that's not worthy of being in its collection, none of which, of course, apply to the Parthenon sculptures. It can voluntarily dispose of Holocaust looted art to its rightful owner, we note the word voluntarily, and can transfer items to other major UK museums. Now, the real problem here is the way the British Museum sees itself as this world collection. And some of you may have heard Sir Neil MacGregor's series on Radio 4, actually a very great work of art in itself, called The History of the World in 100 Objects. And through that, this series of quarter-of-an-hour programmes, he set out the cultural history of the world through these 100 objects, going right back from prehistoric times to the present day. Now, it was a wonderful series, but also it showed what a clever politician Sir Neil MacGregor is, in that one of those objects was, of course, the Parthenon sculptures. And what he's trying to do is to show how the British Museum, because these are all objects from the British Museum, is this wonderful world collection that illustrates the history of the world, and if it's broken up, that continuity would be broken. However, having said that, the British Museum has used the existing powers to dispose of other items. It has sold some of its artefacts. It's admitted selling 30 pieces of Benin bronze in the 1950s and 1960s. The details of those sales are not clear, but it could well predate the 1963 Act, so it may well be of limited relevance as a precedent. But what is known is that they sold 21 duplicate prints in 1986 and a duplicate set of Hiroshige woodblock prints in 1995. Some 2,600 coins, medals and badges and 117 duplicate Western prints have been exchanged for similar material since 1972. The Benin bronzes are often said to be the most similar parallel to the sculptures. 2 bronze plaques from Benin were exchanged for a unique bronze horseman from Benin in 1972. And then an example of human remains. A relic of cannibalism was judged to be unfit to be retained in the collection and was exchanged with Fiji for a collection of prehistoric sherds in 1975. And just moving away from museums slightly, in a private law case in 1991, an English court recognised the legal personality of an Indian temple who were suing for the recovery of an idol, notwithstanding that it was incapable as a temple for having a legal personality under English law. As I said, the closest similarity in those examples is with the Benin bronzes, but of course the facts of that case are different and can be made to fit the existing law. And of course the arguments about the acquisition of the Benin bronzes are very different to those of the Parthenon sculptures. They're effectively claimed to be war booty from the invasion of the Ashanti territory in the 1870s. And there are other precedents too. In World War II, for example, the German museums in Berlin were looted by the Russians, and the Russians took to Russia, for example, the Schliemann treasures of Troy, and are there on exhibition in the Pushkin Museum in Moscow, and the Russians are not going to return them because they say it's war booty and reparations, and we're entitled to keep them, and under international law that may well be a strong argument. But then again, who owns the patrimony in those objects too? Is it Turkey? Is it Greece? Is it Germany? Who knows? And that's an issue beyond this paper. But this is how we end up in this pass-the-parcel approach to the British Museum and government, each saying it's the responsibility of the other. The British Museum considers it's not permitted under its current statutes to engage in negotiations to return the objects in the context of the Parthenon sculptures. The introduction of any legislation for the return of the sculptures will be the responsibility of the government. However, the museum can lend to other museums, including overseas, in tightly controlled circumstances. So it's arguable both ways, under those circumstances, whether in fact the museum could lend the sculptures to Greece under the restrictions in the statute. Those restrictions, of course, being questions around access, the condition of the sculptures, their rarity, and any risks involved in transferring them for loan. So, in the end, if there is going to be any progress, I think there has to be a change in the law. But for a change in the law, of course, there has to be political will too. And it's pretty clear, as Eddie has said, there's no current political will within the coalition government to change the law to overcome these statutory obstacles. When in opposition, their spokesperson said that the relationship between the Department for Culture, Media and Sport and the British Museum is underpinned by a crucial arm's-length principle whereby ministers set the financial, administrative, legal and overall policy framework for public bodies, but those bodies have a considerable and proper measure of independence in individual decision-making. It's been a long-standing policy of successive governments in the UK that decisions related to museum collections are for museum trustees to take, and the government do not intervene. Nor was there any enthusiasm for changing the law under the previous Labour government, though, as Eddie said, there was considerable support from the then Labour backbenchers, with one early day motion, as Eddie said, an expression of opinion of the parliamentarians, attracting over 100 signatures, mainly from the Labour Party. The Labour government's view was that the sculptures were acquired legally, that they're best housed in the British Museum in a multicultural context, seen free of charge by up to 5 million visitors a year. They were clearly the responsibility of the British Museum. The trustees, was the view, have a statutory duty to protect their collections. The duty could only be overridden by primary legislation, then Section 5 of the British Museum Act 1963, related to disposal objects in the collections. So it will need a new law. Can we draft such a bill? So whilst there's no immediate prospect of a reform to enable the return of the sculptures to Greece, what would such a bill look like? And what are the potential problems facing it? These can be categorised both as political and as legal. If a bill is seen to be very specific, referring only to a particular private interest, for example, only to the Parthenon sculptures and their repatriation, there is a strong risk the bill could be deemed to be a hybrid bill. A hybrid bill is a public bill which affects the private interests of a defined particular person or organisation. A hybrid bill is generally initiated by the government on behalf of non-parliamentary bodies such as local authorities. The one we know maybe will come in shortly is on HS2, the new railway. Crossrail was a similar example. And it's treated like a private bill from the beginning of its passage through Parliament. A private bill as a hybrid bill, both give individuals and bodies an opportunity to formally oppose the bill and to seek its amendment before a select committee in either or in both houses of Parliament. This procedure is long drawn out and very problematic, so it's important that any bill that is presented is not a hybrid bill, so it can be drawn as broadly as possible, and certainly not just referring to the Parthenon sculptures. If it's just the Parthenon sculptures, it's hybrid. If it's more broadly in a general application, it's not. So this then, of course, creates the floodgates argument. One of the main arguments deployed against the return of the sculptures is that if they are returned, this feeds the demand for other cultural objects to be repatriated too, such as the Benin bronzes, and no doubt we can all think of many others. The British Museum strongly argues that removal of the marbles to Athens would encourage similar claims for other objects, which would undermine the comparative principle at the heart of the museum's purpose and its collection. And a subset of this argument is the issue of ownership, which I've already dealt with. Of course, the political arguments about floodgates are somewhat spurious because there have been exceptions already, most notably, as I've indicated, the issue of Holocaust restitution and human remains. The only difference, I suppose, is that Holocaust restitution is a rather more recent event. The Holocaust trial is a more recent event and is within living memory, whereas the Parthenon sculptures are in the midst of history. And having said that, though, neither the new law on human remains nor the law on Holocaust restitution have led to a long list of claims. Indeed, some of those who have brought claims for Holocaust restitution have been perfectly prepared to leave them in the collections in return for either acknowledgement of their ownership or compensation. The moral difference appears to be that the events leading to their inclusion in our national collections were more recent than Lord Ailbeen's depredations, and the legislation applies not just to the British Museum, but to a wider range of institutions. But any bill that did not head off this argument would find it opposed in Parliament on those grounds. The bill also needs to overcome the problem of the relationship between the BM and the government, the arm's length relationship that implies ministers cannot order the trustees what to do, and that decisions on the collection should be primarily for the trustees. So the challenge for any bill is to be sufficiently broad to avoid hybridity, yet sufficiently narrow to limit these political problems. Now, I drafted a bill myself, which I presented to Parliament. Coincidentally, it was debated on the same day as the Holocaust Restitution Bill. That became a law, but unfortunately the British Museum 1963 brackets amendment close brackets bill did not. And I've put a copy of the bill as drafted as an annex to my paper. I don't claim it to be perfect in detail and every word, but I think the structure it proposes is the right approach. As I've mentioned, the British Museum is prevented by statute from disposing of objects in its collections, except in limited circumstances. The bill's purpose, my bill, is to amend the British Museum Act 63 to enable the museum to transfer to another institution for public exhibition any object from its collections in certain circumstances. So first of all, it creates a permissive power, which it says it doesn't have at the moment, including things like the conditions of access to view them, the interest of students and visitors to the museum, condition and rarity, and any risks. Pretty well similar to some of its existing provisions, but emphasising them and broadening them. But it also provides an additional power to the Secretary of State to require the museum to transfer an object. And the requirement would be, if in the opinion of the Secretary of State, the object would be more widely accessible to visitors than the British Museum, or where it would be more appropriately displayed in the recipient institution than the British Museum by reason of its historic links, or where the object came to form part of the collection of the museum in circumstances which make its retention in the collections undesirable or inappropriate. Now, that is a general power which is necessary to overcome the hybridity issue, but it's very difficult to think of any objects to which it could apply other than the Parthenon sculptures. So there may well be objects in the collection that I can't think of or don't know, or for which nobody's made a claim, but it's difficult to actually envisage any others. So the bill empowers the trustees to effect a transfer by amending Section 9 of the 1963 Act overcoming the existing restrictions. It is true that the bill provides for the Secretary of State to override the will of the trustees, which is, I have to accept, interferes with the arm's length relationship, but only limited to circumstances, and also a requirement of the bill after consultation with the trustees. In the end, this has to be necessary to provide the political impetus to effect a return of the sculptures. The ownership issue is sidestepped by referring to transfer of the objects rather than ownership and arguing over rights of possession, but brings into play the circumstances of acquisition as one of the possible triggers to bring its powers into effect. The bill also provides that any transfer should be effected at the expense of the receiving institution, which protects the UK public purse, but may, in the short term, present something of an obstacle to Greece, given the present economic crisis. The bill had a second reading commenced on 15th May 2009, and the second reading debate started, but unfortunately there was insufficient time to complete it, and the bill ultimately fell. But nevertheless, I would argue that it provides the best solution framework for legislation to overcome the present legal obstacles, should the parliamentary circumstances change, and it's ready to take off the shelf, as it were, in that eventuality. So that basically is my thesis. Arguments about ownership are somewhat sterile. I think they're dangerous. I think a court case could significantly put back the case, the political and cultural case, if it were to fail, which I think is likely. But there's more than one way of skinning a cat. And I think legislative change could be effected if there's a political will to do it. Thank you.
Thank you, Andrew.